Hi, my name is Charlie Craver. I'm a law professor at George Washington University, where I teach several different courses on legal negotiation. And this is one of the most fundamental skills that lawyers use every single day. And what I find is frequently people come in and ask me similar questions about different issues, and I would like to address some of those issues today. It's amazing how many of these issues come up almost all the time when we negotiate, and the people who come up and ask me about them didn't feel they handled them effectively. So what I would like to do is talk about some of these issues. Number one, it's very helpful if you recognize the different issues involved, and then you can think about how do you counteract those issues when they actually come up during a negotiation. First thing people often ask me, how do you initiate negotiation discussions? Many, many years ago, there was this myth that said the person who opens the negotiation process indicates weakness. Maybe that was true 30 or 40 years ago. It isn't today. If I'm thinking of doing a business deal with you, I will come in and I will say, would you like to talk with me? If I'm the plaintiff, I'm going to tell you I'm either going to sue you or I have filed a complaint. If I'm the defendant and you file the complaint, I'm going to call you up and say, what do you want from me? So when it comes to initiating discussions, don't be afraid to initiate the process, because nothing is worse when you and I should have gotten together and we should have been able to structure a mutually beneficial arrangement of some kind, and we simply didn't. And I see this when I mediate, because I'm amazed how often the first time the two lawyers have ever meaningfully communicated is when I get them together at a joint session. I will talk with them separately before we get to the joint session, and I'll get a lot of information from them, but so often they haven't even spoken.